your lordship.
Yes.
My name is N-O-O. Okay.
Yes.
And joining the piano with me for the said defendant in respect of this matter.
Is that Destina or who?
And my learned friends.
Okay, who are they?
M-O, Ọlọ́run, M-I, Ọlọ́run Mọ́wájú.
M-I,
Ọlọ́run Mọ́wájú is spelled, my lord.
Yes.
O-L-O.
R-U.
O-L-O.
Yes.
R-U-N.
W.
M-O-J-U. W-A-J-U.
Okay, okay. Ọlọ́run wájú, yes.
And A.A. Sonny. Ọlọ́run Mọ́wájú. Ọlọ́run Mọ́wájú. O-L-O.
Yes.
O-L-O-R-U-N.
Yes.
M-O.
M-O.
W-A-J-U.
W-A-J-U.
Okay, okay, my lord. Then equally appearing with us.
Yes. Is A.A. Sunny? Is it A.A. Sunny? Is it A.A. Sunny? We have lost the line SN.
Yeah.
My lord?
Yes, land SN. You
I equally announced the appearance of A.A. Sonny with us.
Okay, thank you.
A.A. Sonny.
Yes. For the defendant.
For the defendant, my lord. For the defendant.
Almighty defendant.
Waiting, my lord, waiting we know. My hands are clean.
Yes, Chinweze. Chinweze.
Yes, Your Honor. Your lordship.
The matter.
Your lordship.
I can hear you.
The matter is, I understand the matter is for adoption. We have
a final written address.
Motion.
But
a motion dated the 14th day of April.
We have a motion for extension of time to file our final written address, and we are ready. Lana is
saying, a motion day of April. Yes, Your Honor.
Lana is saying you are ready. I do not have objection to the motion. Lana is saying. Lana is saying.
My lord.
You are ready and you are not objecting to the
my
motion.
Lord, we are ready. We are ready. We are ready to go on with the matter.
And we are not objecting to the motion.
My Lord, we are not having any objection to the application.
Okay, thank you. Yes, Chinweze.
My Lord, may I move in terms of the
Okay,
motion?
okay. Okay.
To move in terms of our motion paper dated filed on the same day, my Lord.
Thank you. Thank you. So Clement's application for extension of time to file the final written address dated and filed on the 14th of April 2022 is granted as spread. Yes, it's granted as spread.
As God pleases.
Yes, Lana is saying. You are
My
written
Lord,
address.
as defendants in respect of this matter,
Yes.
who actually call witnesses?
Yes.
We call a witness in defense of the case, and as a result
Yes.
of that, we are entitled to first of all file our written address in respect of the matter.
Yes.
Our last appearance in respect of this matter before your lordship was in 2022 in Lagos Division.
Yes.
Our written address within time, defender's final written address on the 1st of March 2022.
Okay. Our final written address is filed or dated?
It was filed on the 1st day of March 2022, my lord. Though
Yes.
dated 1st day of March 2022.
Okay, data and file.
It was filed on the 1st day of
data and
March
file on the 1st March 2022. Yes. Yes.
And it's dated the same day as well.
It's cracking.
1st day of March 2022.
Yes, data and file on the 1st of March 2022.
My lord, upon the claim of our written address,
yes,
when they responded, my lord, by their
yes,
14th April 2022 address,
yes,
which your lordship has now deemed,
yes,
we file our defendant reply address to their written address.
yes, on the 24th of May.
Of May.
Okay. Yes.
My lord, I not
Yes.
only adopt, but I equally rely
Okay. Okay.
on our defender's written address as
Yes.
announced and our reply.
Yes. Okay. Yes. Yes.
My Lord.
Yes.
My Lord, I said we have adopted and rely.
Okay, thank you.
My Lord.
Yes. Yes, I can hear you, Lana, you're saying. Yes.
My Lord.
Yes.
We have raised jurisdictional issue in respect of our written address that the case is statute bad.
Yes, limitation law, yes. But
Yes, and aside from that, my Lord, we commended for the consideration of your lordship the position of the first 9
claimants.
From the position of the 9th to 19 defendants, my Lord, to the 19th claimant.
Yes. That the action is statute bad.
My Lord.
I can hear you, Listen.
Sorry, my Lord. It's a network.
It's network, yes.
Our submission, my Lord, is that based on our argument as canvassed in our written addresses,
yes,
the claimants did not make out a case against the defendant.
Okay.
Sufficient enough to warrant judgment in respect of this matter.
Okay.
That they were never given permanent identity card that regards them as staffs of the MPA.
But they are given offer letters. They are given, the salaries, everything.
As trainees, my Lord.
Okay, not as employees.
Yes, as trainees.
But the offer letter said at the conclusion of the completion of the training, they will be confirmed. Yes. They'll be confirmed as employees.
There was evidence before your lordship that they were not confirmed because the minister decided to close down.
But the lack of confirmation, would that affect the terms contained in the offer?
My Lord, it is only if they continue as employees recognized by the MPA. They were not so recognized.
Oh, okay. So they were not employees; they were trainees.
They were trainees, my Lord.
But they are given staff ID card. They are given offer letters, isn't it?
Not in capacity as permanent staff of that body, MPA, my Lord. They were never.
Okay.
I will urge your lordship to critically go through our submission. We want your lordship and consider the evidence of their witnesses and our questions to them under cross-examination and their response. and their response.
Okay. Okay.
So if your lordship will be convinced.
But
they were never so regarded.
But the letter is saying offer of admission / appointment as a technical trainee.
Yes, my lord, sir. That's where we are relying on that. They were technical trainees. They were technical trainees. Technical trainees. Why was the usage of the expression trainees? If they have become permanent members of staff of MPA, there is no reason to really go through and use the expression trainees. It will categorically regard them as members of Nigeria Post Authority, my lord.
Okay, then why is the ID card is reflected on the ID card staff? It's saying staff. Staff.
My lord, the moment they were still training, they are regarded as staff for the purpose of securing their identity. That in case of anything happens, the relationship will be traced to the MPA at that particular time, so that they will not just be outside without having any identity individually.
But what they are saying is that they have concluded the training, and what you only do was to deploy them, but you fail or refuse to do that.
They refuse to do training. That particular time, that college was closed up. They were no longer admitting, and as a result of that, they were not able to deploy them.
But they are recalled.
My lord, your lordship will record that they record them for the purpose of completing their training, so that they will have a certificate to that effect that they completed that training exercise. I want your lordship to go through the evidence as I did, sir.
I've gone through it. I've gone through it.
And the rest, yes.
I've gone through I look at okay. Then what should we say about this clause in the offer letter? Upon successful completion of the probation period, your admission / appointment may be confirmed.
Maybe. 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 And usage of the expression may, a first opportunity of disruption may be. It's not conclusive that you'll be confirmed. Maybe. And they were not able to bring any letter, were never able to bring any letter confirming the appointment. If that letter has been produced, we would have succumbed to their.
Yes, I can hear you. Yes, Land is saying.
So, my lord, that is our position, sir. If immediately after that letter that your. My lord.
And with regards to the issue of limitation law, they said
yes,
you cited an old law, Ports Act, of 1950 something.
My lord,
which is the one that made provision for the, limitation period to
file
any case against the authority.
My lord,
but the law of
my lord.
Yes. Yes, I can hear you.
I'm hearing you, sir.
Yes, but they are saying that the current
my
law.
Lord, our position. What is it?
No, they're saying in your argument that the action is statute bad. You cited an old law, but the current law doesn't have that provisions. You understand? as contained in the old law. In the new law, that is the Nigerian Ports Authority law, there's no that provision for limitation law, limitation period within which a claimant can institute an action against the Nigerian Port Authority. That's what they are saying in their argument.
My Lord, if I may say this,
yes, and they're also saying raising the issue of continuous injury.
My Lord,
yes, I can hear you.
The argument that there's no limitation that any person can wake up at any time and say he's having an action against another person?
Yeah.
If they are saying they are citing the old law, the question is there no limitation law again?
Okay.
There's no limitation law that anybody can sue at any time.
Which law is that? Which law is that? I don't know about it, though, as far as I'm concerned. Is there any law? In the old law,
well, my Lord,
in the old law, there is a provision that provides for limitation period. Then in the new law, they are saying that it's not provided.
Man, it is for them to produce the new law that is applicable. It is not for us. We have cited our own. Let them produce their own law.
It's for you. It's for you when you are replying. It's for you to say the new law also contains similar provisions. As far as they are concerned, they brought their case. Their case is within time. And they even said that it's a continuous injury. What do you say?
If we are continuous injury, because the moment it ended that they did not engage them or confirm their appointment, that was when the cause of action actually arose. Since 2007, did they go to call until 2019 or 2010? My Lord, my argument is this, sir. If they say that our law is not applicable, let them give your lordship for your lordship consideration the present applicable law on issue of limit.
My Lord, if I may come in.
No,
my Lord, if I may.
No,
don't right to reply when his lordship is through with me.
You have your turn. You'll have your turn.
Yes, your lordship.
I can hear you. Yes, Landa is saying. Sorry for the interjection. I can hear you.
So, my lord, sir, the conclusion of our argument is that
you are now saying that it is for the claimants to produce the law, the new law.
Yes.
That
now
is...
reason that our law is not applicable. It is not sufficient to say that our law is not, as cited by us, is not applicable. The onus now shifts on them that this is the current position of law in terms of statute of limitation in contractual matters.
Okay.
It is their duty. They should bring out the relevant law, not merely condemning that is not the applicable law. The onus now shifts on them to say the current position of the law is so, my lord, sir. Not merely saying you are citing old law. What is the current law that is known to them?
The current law is the Nigerian Port Authority Act, isn't it, of 1990?
Very well, your lordship.
And they are saying that law doesn't contain any limitation period within which a claimant will sue can institute an action against the Nigerian Port Authority.
My lord, the question now arises, if they are arguing that way, the question arises, are they saying that no law, limitation law of general application?
What is the limitation law of general application, please? Let us say.
My lord, in 6 years in civil matters. 6 years in civil matters.
Yeah, but limitation law is an issue of status, not an issue of common law. It's an issue of status.
Yes.
It's a statutory issue. So what is that law saying that no action shall be instituted against the Nigerian Port Authority unless it's commenced within so and so time? That's what I want. If that law is not brought to me, how can I act on it?
My lord, since it is an issue of law, since it is an issue of law that it requires no evidence, we will make available to your lordship that relevant provision of the statute that says they cannot take any action upon
No, relevant statutes of the Nigerian Port Authority, not any other law.
Yes.
Not any other law, isn't it? It's okay. It's okay. It's okay.
Yes.
So the issue of continuous injury, you said, is the cause of action arose from the time that they are not confirmed and they are not deployed, isn't it?
Yes. Yes,
Okay.
my Lord, sir.
Okay.
Thank you very much, sir.
That is saying, thank you so much.
We pray that the good Lord will give your Lordship divine wisdom for the purpose of resolving this matter.
God willing. Amen. God willing. Thank you. Okay, let me get back to this.
My Lord, the claimants filed their final written address, and it is dated. It is dated the 14th day of April 2022. Filed on the same day.
And filed.
On the 14th day.
Yes, of April 2022. Yes.
Yes, your Lordship.
Yes.
My Lord, in the statute, we seek to adopt that written address, your Lord, as our final address on this matter. And my Lord, flowing from the address we have canvassed before your Lordship.
Yes.
We submitted that the claimants are employees of the defendants, and their employment with the defendant.
How are the employees?
Your Lordship.
How are the employees?
They were, my Lord, they were appointed, they were given letters of appointment.
But the letter is saying offer of appointment, offer of admission / appointment as a technical trainee.
Yes, your Lordship.
Technical trainee, how would that be an appointment?
My Lord, they were appointed, they were given salaries, they were paid salaries, they were given grade level of their appointment in the service. They were placed on grade level JSS 3.
3.
Yes. They were paid salaries.
Okay.
They also, yes, they were paid. They were appointed. They were issued ID card as staff. If my Lord would look at the ID card critically, you would see clearly that it is stated staff on the body of the ID card.
Yes,
and their ranks were trainees. Their ranks were trainees. That's their designation, trainees. But the ID card is stated staff.
Okay, rank is saying technical trainee.
Yes, but the ID card, if you look at all the ID cards, the upper part is written staff. It's a staff ID. It's a staff ID with rank. You know, like everybody in an organization.
But as a technical trainee.
Yes, your Lord.
And they may be deployed at the completion of the training.
At the successful completion, my Lord. Look at the
But the offer is saying may. It's saying may. They may be, you may be. That's what it's saying.
My Lordship, they were placed on a 1-year probation. The letter clearly states that they were placed on a 1-year probation. So,
okay.
My Lord, and they kept on paying them salaries even after 1 year to a span of 4 years.
Okay, sorry. Okay, so the confirmation is with regards to the probationary period, not with regards to the completion.
Your Lordship. Yes, so they said after probationary period of 1 year.
Okay.
So they failed to. It is on them because they kept on paying them salaries even after the 1-year probationary period, my Lord.
Yes.
And what is the essence of probation? The essence of probation.
No. Once you don't, even if you don't confirm somebody, once you pass that period of
probation and you kept paying salary.
No, he'll be deemed confirmed. Yes. He'll be deemed confirmed. Yes, that is the position of the law. Yes, but I'm just talking about the issue of the employment. How will they be said to have been employees of the Nigerian Port Authority, because he said, I'm pleased to inform you that as a result of your performance in the just concluded examination/interview of the above named center, you have been offered an admission as a technical trainee in the authority, in the authority's pensionable services. Let us say, it's even saying pensionable services.
Pensionable, very well. Yeah, Lord.
Let us say, yes, can you hear me? It's even saying, let me read you the first paragraph. Okay. He said, I'm pleased to inform you that as a result of your performance in the just concluded examination/interview of the above named center, yes, you have been offered an admission as a technical trainee in the authority's pensionable service on a commencing salary grade JSS3 in the authority's salary structure. So you are saying pensionable service of the defendant.
That is on their
salary. I'm hearing. So you said, I can't hear you. I'm
hearing you. I'm hearing you, sir.
It's saying you have been offered an admission as a technical trainee in the authority's pensionable service on a commencing salary grade JSS3 in the authority's salary structure. So didn't this, show that they were employed as permanent and pensionable staff of the defendant?
My Lord, there is no evidence before your Lordship during the trial of this matter that they were regarded as permanent members and that they were distributed to various aspects of the department of MPA. There is no evidence before your Lordship like that. They were disengaged because that school was actually closed down, and I made a submission to the effect, my Lord, that they were
disengaged as staff. Disengaged as staff?
As staff, trainees, technical trainees. My Lord, technical trainees. If they were staff, they would not have included the expression or usage of the word technical trainees. Was there any letter that followed technical trainees, my Lord? There was none. If they have been issued one, they would have provided them during the trial of this matter. They were never engaged.
But why did you say that they are engaged, in the authority's pensionable service? In the authority?
After the training, my Lord, after the training, they would have succeeded in moving from technical training to the permanent staff. But in as much they were not dispatched, my Lord, in as much as they were not dispatched, can we regard them as such when there's no letter to that effect? If a letter has minor technical training.
Okay, then it means after the completion of the training and the defender refuses, to deploy them, it means that the breach of contract, isn't it? Does that mean that there's a breach of contract? I say after training.
My Lord, I will not regard it as a breach of contract because there is an expression that they may.
No, that may is with regards to confirmation.
Yes, my Lord, sir.
That may is relating to confirmation after the.
They were never confirmed, my Lord.
Yes, but the position of the law is that once you've engaged somebody and you have stated in the letter that you'll be confirmed within so time, the fact that you haven't formally confirmed him, once he has passed that period, and you continue to pay him salary, you continue to engage him, he'll be deemed, the court will deem him as confirmed. That's the position of the law.
My Lord,
sorry, it's cracking. It's cracking.
Capacity. My Lord, I said, in what capacity? Is the letter to the effect that the completion of the training. They are not, you are now.
If after the completion of the training,
individual of them, that this is your position. You go to this place, this is your position. Okay. Stable. My Lord?
Yes, I can hear you.
Yes, the network is not actually stable, but yes, we have made our own submissions, my Lord, and your Lordship has equally having the opportunity of listening to the submission of the Learned Council, my dear sister Chinweze. Your Lordship has the right to look at the whole evidence before your Lordship, the written addresses that follow thereafter, and determine which way the judgment should go. And every individual of us, whether the claimant or the defendants, have every further constitutional rights in whatever way. I pray the good Lord will direct you and guide you aright.
Thank you so much. Thank you so much.
My pleasure, sir. Are you coming to Lagos for the break?
No. I'll be going to Abuja. Sorry to.
My Lordship, I'm so sorry.
Yes. Okay, you haven't concluded, but you want to conclude?
Yes. Okay, I think to adopt, my Lord.
Okay, yes.
And my Lord, the learned seal asks for the section of the law that is the instant law of MPA. Yes. It is well stated in our written address. The instant law of which the instant law is Nigerian Port Authority Act. Cap N126 126.
So is the extant law?
My Lord?
The extant law. It is the extant law.
It's the current law. It's the current law.
And it doesn't have provision for limitation.
Not at all. Not at all. In fact, section 125 sub 1 of the law specifically repealed the law, the Port Authority law. And so there was no.
Okay, but is there a saving clause? Is there any clause in the extant law that saves, those provisions contained in the law?
Those old provisions were not contained, and it was clearly repealed. It is not contained in any section of the new law, my Lord.
Yes, but sometimes after the repeal, the extant law would now sometimes, you understand, save some clauses.
Yes, your Lordship.
Contained in the former law. So my question is there any?
There is no provision whatsoever incorporating the old law or any clause in the old law into the new law. It is well stated.
Okay. So, students, as far as we are concerned, they are employees.
Very well, your Lordship. They are employees.
Yes.
Your Lordship.
It's straightforward.
Yes, so they're employed because the ID card is saying their staff, and the offer letters are saying that they are engaged.
Yes, your Lordship. They are engaged under the pensionable system of the MPA.
Okay.
That is the only letter they are having in their discussion.
That's the only letter.
Letter after.
They also
my
have
Lord,
the certificate. Yes,
my
I can
Lord,
hear you. Yes.
They were issued, even when they closed the institute, they were called back and they were issued letters of recall. And they specifically told them in that letter that the period in which the school was on closure will be regarded as leave period, and they were adequately paid for that period as their leave entitlement, your lordship. NPA never at any point did NPA issue them a termination letter. There was no form of termination letter or instrument of termination from NPA to them. Not at all. My lord, there are scenarios where, even in the Federal Civil Service, when staffs are not paid for a period of time. My lord, when staff are not paid for a period of time, even in the Federal Civil Service, that would not be regarded as a termination.
Lord, they cannot be given. They should only be given.
My lord, I'm still speaking, my lord. I'm still speaking, my lord. I believe this is my. I said even in the during. Yes, my lord.
There's even something that I've seen now written on the offer. It's saying your first year of admission will be a period of probation, and subject to termination by either side on 1 month's notice or salary in lieu. So if it's not, Lana is saying, if it's not employment, why is the offer saying termination? And why is he saying 1 month salary or salary in lieu of notice? If it's not employment, why is he calling termination? Why is he saying if somebody will wants to terminate, you have to pay salary, 1 month salary in lieu of notice?
If there is no any letter of confirmation, my lord, if there is no any other letter of confirmation as trainees, my lord, sir, they cannot enjoy all these benefits that are meant for permanent members of staff. Your lordship will recall that even in the evidence, they said they were recalled for the purpose of completion, not for the purpose of engaging them, but to ensure that they were having issuable certificate of completion. Otherwise, they would have allowed them to go without the completion, but that it will be injustice for them not to complete. But they are not talking in terms of engagement after the completion, and that's why there was no letter after the completion that you are now engaged and you are not distributed or dispatched to various departments of the NPA. There should have been a follow-up letter.
My lord.
Okay,
my
okay.
Lord.
Yes,
My
I
lord,
can hear you.
My lord, NPA is not a one-man business. NPA is an institution, and they very well know the import of an agreement or a letter of agreement to employ someone, my lord. The letter clearly states, as my lordship has pointed out, that they were even entitled to 1 month's salary in lieu of notice or 1 month's salary in itself. My lord, they were never, ever given any letter of termination.
That's not disputed.
They were never given notice. They were never given. They kept on.
In what capacity have been given such a letter? In what capacity? As trainees or permanent staff of members of staff?
Yes, because why should the letter have that clause in the offer? If it doesn't regard them as employees, why should he say that at the termination?
My lord, they regard them as technical training employees, not as permanent. Okay. Let me ask you a question, sir.
Yes.
What was the description given to them in their letter of appointment? What description was given to them apart from technical trainees? Were they specifically supervisor? You are this, you are that.
Okay. You now agree with me that you now agree with me that there's no 1 month notice given to the. So it's cracking.
They regarded all of them as technical trainees. Otherwise, they would have given them different types.
No, what I'm trying to ask is that Lana is saying, the offer letter contains a clause saying that in the case of termination, 1 month.
I don't think there was any specific notice further upon the completion.
Eh?
My lord, they were never terminated, my lord. My lord, sir. My lord, they were never terminated. They were paid for the period under which they technical training. They were paid for all the period. And when they were calling them for the purpose of completing their program, they regard the period as period of leave. So that it will give the impression that during their training, they were given a month notice for the purpose of completing that assignment.
Okay.
Technical trainees. My lord, we have various appellations for individual who is regarded as a permanent worker. You can be called a foreman, a supervisor, or an engineer, or whatever. There's no letter to that effect. It means that up to that particular level, they were still regarded, having not been jobbed permanently as technical trainees who succeeded in completing their technical training program. And they were issued a certificate to that effect, and they were being paid during the period they were actually undergoing the training. They did not say that they were indebted to them, that there was they didn't pay them anything. And we asked them under cross-examination that, where do you work? They said they didn't engage us.
Yes.
And they were living in the house. Where were you assigned? They said we were not assigned to anywhere. Their relationship with NPA ended at the point of the completion of their training, my lord.
My lord, they are still staff, my lord. My lord, I will seek to adopt our process and urge my lord to grant, the claimant's claims and their reliefs, my lord.
Okay.
Most grateful, your lordship.
Thank you.
My lord, just a minute, sir.
Okay, Lanes.
Is it from?
Even from it shows me.
Thank you, my lord.
Lanes, you're welcome back. You're welcome back. Thank you so much. I've heard you, and I'm going to go and I'm going to go and go through everything again. I've read all of them, but I'm still going to go and Lanisen, I want to ask this question. Don't you think that since there is a sort of ambiguity with regards to the claimants are saying that it's an employment, while the defendant is saying that no, they are technical trainees.
Yes,
so
my lord.
That ambiguity shouldn't be resolved in favor of the of the claimants?
My lord, there is no ambiguity. If my lord,
from the offer letter, at some point you say in the authorities pensionable service, At another point, you call them technical trainees. At another point, you say your first year of admission will be a period of probation and subject to termination by either side. So what brought about the issue of termination? And we are saying, in all those terminologies, termination, probation, engagement, pensionable, those things, are they not in favor of the claimants? Because when you give somebody an offer,
they can't be in their favor.
You give somebody an offer, so you are saying it's a technical training, but in the offer letter you are saying probation period, you are saying termination, you are saying salary in lieu of notice.
My lord, that is after probation, after a real engagement, that they become permanent staff of MPA. But in as much as there was no graduation from technical trainees officially, my lord, they still at the last promotion. What I mean by promotion is that they were merely technical trainees. Whatever the terminology that may be used, it will only be applicable upon letter of appointment, individual appellation of the nature of the employment they were given. If something has actually conclusively cancelled their appellation as technical trainees, all other provisions will be applicable to them. But if they cannot bring out any, my lord, sir, the appointment or whatever, hence as technical trainees who succeeded in completing that particular program.
I think it went out to deploy
my lord, sir, my lord, if your lordship, my lord, if your lordship looks especially at their claims, particularly third, second and third, listen, my lords, are carefully to what you are saying. Another directing the defendant to immediately deploy the claimants to their respective departments in line with the claimant's letter of appointment. Another directing the defendant to immediately deploy. They were never deployed.
My lords, claim number what?
That's claim number 3, my lord. Claim number 3.
Number 3.
Yes. They were never deployed. They were praying for deployment, but because they know that they were not fully engaged as at that time. My lord, sir.
That's a follow-up. It's a follow-up this thing order. The first and second, which are declaratory, they are saying that it is after making the declarations that the claimants as members, that it's after the court has made the declaration that they are members of staff, then the order number 3 will now come, that that the court should also ask the other defendant to immediately deploy the claimant, because it had already made an order, a declaratory order in number 1 and 2. So I think that number 3, it's a follow-up, order.
Consequential relief.
When Lana is saying,
my lord,
when a person is engaged by the Nigerian police and the Nigerian military,
yes, my lord,
police academy or NDA,
yes, my lord,
I thought his services, his career service in the police or in the military will start from the time he was admitted into the academy, either Nigerian Defense Academy or Nigerian Police, Police Academy. Isn't it?
My lord, it isn't, sir. This one is a contract staff, my lord, sir. Contract staff. They are contract staff, and they have levels. You go first of all through this phase. If we now recognize you at the second phase, we move you in. But the question is that they were never moved in, and that's why they are seeking for relief number 3. That
what I'm saying is that relief number 3 is a follow-up relief, because they are only asking for relief. Relief number 3 will only be granted when reliefs number 1 and 2, that's the declaratory reliefs, are granted by the court.
I see direct the attention of your lordship most respectfully to even relief number 2. A declaring that the defendant failure to fulfill his contractual obligation to the claimant by paying them their wages, allowances, and other arrangements as due and deploying them to their respective departments. Never deployed, my lord. They were never. Why should they be paying them? In what capacity would they be paying them when they were never deployed? My lord, I leave everything to the exercise of judicial discretion of your lordship, guided by the law.
Thank you so much, I appreciate that.
They are not praying your lordship to let it happen because they knew that truthfully it did not happen. Thank you, my lord, sir.
That is, I'm thankful to you. I'm the Chinweze. I also appreciate you. Thank you so much for for your patience. So case is now adjourned for judgment to a date to be communicated to counsel via Zoom. So I will communicate the date to you when it's ready, please.
Thank you, sir.
I wish you Happy New Year in advance, and in any case, and next year will be pre-election year, ba?
Yeah, it is going to be.
I hope you have our time.
Okay. All right, sir.
Thank you so
from the bottom of my heart, I wish you well and best of the new year.
Thank you so much. I wish you the same.
Chinweze?
Yes, Chinweze.
Okay, Chinweze? All right, sir. Thank you, sir.
Okay, thank you. In the absence of any other thing, I believe in. Good afternoon. Thank you.
My lord.
Yeah, Hajia. Hajia.
Good afternoon, sir.
Thank you, sir.
You have joined?
Yeah. I've joined.
Good afternoon. How are
you? Good afternoon.
Lana Yassian, Hajia is greeting you, the registrar.
Ladi. You abandoned us for almost 3-4 years.
I did not abandon you, sir. You did not ask of me, sir. You didn't ask of me.
What about Odumosu? Odumosu was regularly giving me information concerning you.
Thank you, sir.
I'm very appreciative. It is well with you.
Yes, sir.
Thank you and remain blessed.
Thank you, sir. Thank you, sir.
Okay.
Thank you. Sir.
Okay, thank you. Bye-bye. Okay.
Yes, I did not know it was 11. I just checked.
I will call you on phone. We'll talk.
Okay, sir. Okay, sir. Wow.
Come on, Fred. Please, has it ended? Hello? Somebody is there. Is there? Hello? I can't hear you, please.
Sorry, it was on mute.
Okay, has it ended?
Yes.